Silindile, thank you very much for your time. We understand you're at the Constitutional Court right now outside, ahead of that case tomorrow. What are you hearing from analysis out there about exactly the issues that she's challenging, being her ability to have a legal representative, also the separation of powers doctrine, as well as the all-important retrospective application of the law in this instance, where she says these rules were actually formulated after the events, they should apply to the next public protector?
Mfundo, it's been quite a process which started in 2019 after that High Court found she had acted dishonestly in her investigations into the Reserve Bank granting Bancorp that loan, which is now Absa Bank. Now, she appealed that decision, but she was still unsuccessful and was ordered to pay a partial the Reserve Bank's legal costs. And the Constitutional Court upheld that decision, which is now what gave birth to the independent panel that was chaired by former Constitutional Court Judge Bess Ngabinde. She was supposed to assess the effect if there was evidence of her ineffectiveness, misconduct and incapacity, and she did find evidence of that. Now that meant the Section 194 parliamentary inquiry would begin, but just as it was beginning, the Public Protector went to the Western Cape High Court to say, hold on, I feel like these rules that are being set up are unfair to me, and the fact that this committee is birthed of a panel that was chaired by a former Constitutional Court judge may breach the separation of powers doctrine. But I'm joined by Elton Hart, who is a legal expert and is going to give us more insight regarding this matter. Elton, so the Speaker of Parliament and the Democratic Alliance are here at this court tomorrow. What do they want from the Constitutional Court?
If one looks at it, and one looks at it very nicely, the Speaker has now approached this court together with the DA to say what the Western Court, High Court has said, that the rules pertaining to Mkhwebane's approach to the court, because Mkhwebane approached the court and asked the court to say that these rules were specifically designed in December 2019 to target me, if one put it in layman's terms. And then the court said, okay, the rules does not need to, they gave Mkhwebane some sort of relief. Now the court, the DA and the Speaker of Parliament is at court saying to the court, we want to say, overturn that decision by the High Court in Western Cape, and we want to say, halt all the proceedings pending the outcome of this appeal. So they technically going on appeal as to what the High Court has said. And the High Court said further, in that investigation where it was headed by former Justice Ngabinde, that committee, which is a subcommittee of the National Assembly, that had to look into the incompetence, incapacity or misconduct, if whatever they want to call it, of the Public Protector, to say, but when she appeared there, that court on the High Court said she's entitled to legal representation, and that court gave her that relief. Now they're coming to this court to say overturn that, which means, in essence, for me as a legal representative, it looks like they want to say to the court also, this court must say she's not entitled to legal representation in that specific committee, which I think then speaks against the grain of the Constitution. And I think the court should now be very, very careful and cat feet around how they deal with the situation. But we'll see how it unfolds. But I think already, because the former Justice Ngabinde was on that committee, I think also for the layman and for the Public Protector, this might spell some sort of thinking there's bias, or there might be bias in what's going to happen tomorrow in this court. That's how I see it, but we'll have to see how the process unfolds.
Does what happens in this court in the coming days in any way impact on how the future heads of Chapter 9 institutions are going to be removed?
Obviously, this court will set a precedent as to, if they say that that rules is good in if we look at the constitutionality of it, that you say this is the procedure that will be followed by either the National Assembly or a committee of a subcommittee of the National Assembly in removing Chapter 9 heads, then obviously if this court say there was nothing wrong in how they did it and how the rules was amended, then it means it becomes precedent and that will be used in future. And also if they say that how the committee operated on itself also means that a head of a Chapter 9 institution does not have the right to have legal representation when he or she is being interviewed or there's an investigation pending or ongoing against that head of that Chapter 9 institution, then it speaks to something about your rights as an individual in South Africa, which is enshrined in the equality, human dignity, all those things, and also fair and just processes. So then one needs to now look as to, because this will create a precedent, and once this court sets that precedent, it means that the courts below it is then bound by that precedent.
Now, the public protector argues that the fact that that independent panel that birthed the establishment of the 194 Parliament, the Section 194 inquiry by Parliament, is the fact that it was chaired by a former Constitutional Court judge, and the Western Cape High Court says a judge cannot be part of an independent panel which must decide on whether there is a prima facie case in the removal of a head of a Chapter 9 institution.
Let me just, because the mask makes me difficult to explain, but I'll keep the 1.5 distance from you. It's separation of powers is very important if one looks at it. You have the legislature, you have the judiciary, and you have the executive. And each one has its specific function. Now we have a former justice. Although she's a former justice, she performed a legislative function here. And for the man on the street, this can create difficulty because I'm sitting there and thinking, okay, this court where the former justice, and I'm not speaking to the justice's integrity, she was a member of this court, and they normally refer to my brother and my sister in this court, and she's been working with them for a very long time. Now for Mkhwebane coming to this court, she thinks already, although maybe the justice is not here, she might still have friends sitting in this court, and in the back of her mind she might think that they will maybe side with their former sister or brother if it was a male that was sitting on that committee. So that little thing sits there in the back of the mind of a person, and a lay person would obviously see it in that way. Maybe we can say that the judge has acted impartial and everything, but still that problem is there. So for me, I think they should have chosen somebody completely independent that has no role to play in either the legislature or the judiciary or even the executive to be the head of that panel, but obviously a person that has the legal expertise and training so that they can actually interpret the legislation and make sure whatever is being done here is in line with our constitution. So that's how I see it. But I think that they asked Justice Mkhwebane to say they might just create that perception. I'm not saying that there must be bias, but I'm saying that perception of bias is created by that move.
That was Elton Hart. Thank you very much for that analysis. He's an attorney at the University of Johannesburg's Law Clinic. So tomorrow, the Constitutional Court starts hearing the National Assembly Speaker and the Democratic Alliance versus the Public Protector. It wants the Constitutional Court, this court, to grant it direct appeal to appeal the judgment and order by the Western Cape High Court. Back to you in studio, Mfundo.
No, thank you very much, Silindile.